Hey guys, it's Christine here. Thanks so much for tuning in to my last live summary from court in British Columbia. I'm going to tell you about what happened in court today. Today was a really weird day, mostly because I actually did not get to go to court for really complicated reasons. There was a security threat at court this morning. A sheriff was posted in the courtroom, and it wasn't appropriate or safe for me to be in the courtroom. So I had to watch. I got a live stream of court, and I got to watch from my hotel room. So it was actually pretty disappointing for me to come all the way to Vancouver, only to be faced with this security threat and then not be able to attend in person. I mean, this was an actual threat. The police came. So I'm grateful that I was able to observe online and that I'm safe and everything is fine for me, but it still was an uncomfortable situation. And it was disappointing that I didn't actually get to observe in person, because this case really matters a lot to me, as it matters to all of you. I've worked really hard on this case. I've been involved in it for a really long time. It meant a lot to me to come all the way to Vancouver to be a part of it. And I wish I could have been able to be in the courtroom, but as I said, it wasn't safe, and that's why the police were there. I don't want to say too much more about it because it's an uncomfortable situation, but everything is fine, so don't worry. So what happened this morning, I observed online, but the court began by giving their written reasons for the decision on mootness. They had given an oral ruling on why they were proceeding to hear the case on the merits, even though they said the case was moot. They kicked some of the parties off. They kicked off one organization, but they allowed an individual to remain, Kip Warner. They removed his organization, though. And then there was another individual named Maddock, and they removed him. And they allowed us to proceed. They gave written reasons today. They orally read their written reasons about that today. I mean, I gave you all the update on Wednesday about the decision on mootness, so this isn't news, but they just wanted to outline the reason. They said it was important for our case, the Canadian Constitution Foundation's case, to proceed because the CCF had taken the lead role in this. And then after reading the decision on mootness, they they did a short break and came back on the merits of the case. And you know, that began with the lawyer for Kip Warner, who was another party in this case. She wrapped up answering a few questions that the judges had left her with last night. I won't summarize any of that, but the biggest part of today was the government responding to our arguments on the appeal. So the government, when they came back, when we started for the day, the lawyers for the British Columbia government argued first that, to address our arguments, the list for medical exemptions, they said it was an open list, not a closed list, even though there was that 6 tick boxes. You needed to have a certain government identified and approved medical conditions in order to even apply for an exemption. The government responded, no, that was a misunderstanding. You could fill in whatever you wanted. You didn't have to tick one of those boxes, even though that's what the form said. And then the government also said that there was no activity by activity exemption, that all exemptions were blanket exemptions. If you'll recall from my previous videos and from how I've talked about this case, one of the petitioners in our case, a young girl named Erica, she developed pericarditis, which is a government-approved medical condition for an exemption. But the government had said in order for her to, on their form, in order for her to get an exemption, she needed to apply anytime she wanted to do an activity or event. And the court said, look, if you're going to make this claim about activity by activity exemptions not being a real thing, that Erica could have got a blanket exemption, you're going to have to show us the evidence. We want to show the evidence. And the government said, well, first, let's talk about the purpose of the orders. The purpose of the orders wasn't to incentivize vaccination, although they said that was part of a purpose. They said Another part of it did relate to transmission. And they said that our appeal, the Canadian Constitution Foundation's appeal, is about the medical exemption process, but the public health, they said, needed to design a process that looked at what was happening with unvaccinated people, how they said unvaccinated people became sicker and were more likely to be hospitalized. They were hospitalized at a higher rate. And the government said the public health office also needed to consider how there were vulnerable people in society who, even if they were vaccinated, were not able to mount a sufficient immune response. And they said that is important. And that all feeds into the context of this exemption process. They argued that this was a completely open process to get a medical exemption, that you didn't need one of those approved conditions, that, you know, even though it was open, though, they said medical evaluation is still important because public health can't know the individual medical situations of different applicants. So they had this requirement for a doctor's letter. And, you know, the court had some questions about, you know, these are kind of technical questions, but were these exemptions reconsiderations of the order themselves, or were they exemptions? And they said, well, you could make a request for a reconsideration with additional information that public health didn't have. But the court said, you know, is that a modification of the order itself? And the government said yes. So the court asked, so there has never been a reconsideration of an individual situation, then it's a reconsideration of the order. You know, I don't quite know where the court was going with this line of questioning, but the government conceded, yes, it's a reconsideration of the order itself. The government, on this question of whether or not it was an open list of medical exemptions or a closed list of medical exemptions, we say it was a closed list. The government says it was open. The government says, you know, these forms that the CCF is concerned with, that form with that tick box with the list of approved conditions, they don't dispute that that was incorporated by reference into the public health orders. They also talked about, though, that at the bottom of some of these forms, there was language that talked about pre-existing medical conditions. And they said that that language at the bottom in these footnotes was not exclusive language. It was open-ended language. And they said that our petitioners, like Erica, like Sharon, who had another adverse reaction, they said that our petitioners didn't engage with the remedy of seeking a reconsideration at all. And that if the petitioners in our case had put in a request, it would have been addressed, even if there was some missing information, as there was in Sharon's case, they would have still been considered. And then the court turned to this really interesting question of whether or not the College of Physicians, which is the regulator of doctors, had created, in collaboration with public health in British Columbia, a chilling effect on doctors, whether or not they had put this soft warning to doctors that doctors and physicians and nurse practitioners should not consider writing letters to support claims for medical exemptions from the vaccine passport program unless it was one of those 6 listed conditions. And this is really important because the practical effect of that is if the government says this is an open forum, but they worked with public health, worked with the regulator to tell doctors not to write these letters, I mean, then it's not an open forum, right? And the government said, when you look at the this letter sent from public health, it was a press release. When you look at this press release from the College of Physicians, it attributes a position to public health, saying public health will only consider these specific types of conditions. And the government said, I have to think about this. I'm going to address this after lunch. So this was a really, really important issue. I can jump to what the government said about this, but let me first consider something else, because they didn't answer this question until after lunch. But keep this in your mind, that the court really is engaged on this question of whether or not the government created a situation where doctors were actually afraid to fill out this letter. And this was something that we raised at the lower court. The lower court said this is hearsay evidence, that if we wanted to make this claim, we needed to include the regulator, we needed to include the College of Physicians. But it's really something that the Court of Appeal here was engaging with. And one of the responses the government had to this is, Erica's doctor filled out the form. So you can see that doctors weren't afraid to fill out forms to support exemptions. But the court said, what are you talking about? Erica had one of the listed conditions. Of course, her doctor wouldn't be afraid to fill out the form, because the regulator said only write letters to support exemptions for listed medical conditions. And Erica had a listed medical condition. And the government said, well, the Canadian Constitution Foundation has said that physician fear prevented doctors from filling out the form. And the court was like, no, this is one of the listed conditions, but they took the government's point that at the lower court, the court hadn't found that physician fear was present and that there was a lack of evidentiary basis to even make those claims. So then the government turned to Veronica's case. So if you'll recall, Veronica, she is our petitioner who had complex and overlapping disabilities. She did not get vaccinated because she did not feel like a person in her body who had all of these adverse drug reactions, a history of many adverse drug reactions. She had a very complicated disability. She'd had many surgeries. She just was in a body that struggled with medical interventions a lot. So, Veronica wanted to access the pool for swim therapy. And the court said they asked about Veronica doing her own research. And I talked about this in the video yesterday. Veronica doesn't say she did her own research. What Veronica says is that she looked online to see if there had been any studies about people with her medical conditions getting the COVID vaccine, and she couldn't find any information about that. There wasn't any study about a person in a body like hers. So I think it's a little patronizing to say, it's a little suggestive that she's some type of conspiracy theorist, like she went online and did her own research. Like part of her research is actually living in the body that she has and knowing what her medical history is. That's not doing your own research in some negative way. It's just her life and her body, and she knows what her body is like. So the court said, well, it is the research she did to see if there were studies about her own condition. So it seemed like the court recognized that their earlier statement about this doing your own research, that maybe there was that wasn't quite what they had, the way it had come off originally. They maybe were trying to say they meant something else by it. The government responded by saying, well, in Veronica's case, what we should focus on is that there isn't a healthcare provider for Veronica saying that she shouldn't get vaccinated. Veronica's just saying it's her own opinion. And the court, the government said, it's just her own opinion evidence that she has a contraindication. There's no medical evidence. She also doesn't explain about asking for a letter for her doctor. But remember, from our position, what we're asking for Veronica is not for the court to find she was entitled to an exemption or to grant her an exemption now. I mean, these haven't been enforced for 17 months. It's to find that her rights were violated by not giving her the option to apply at all. Like there was not even an option for Veronica to be considered. So then the government turned to the third woman in our case, a woman named Sharon. And she is the woman in our case who had an adverse reaction to the first dose that left her with a condition called brachial neuritis. And her neurologist and a doctor called a physiatrist, which is a different type of rehabilitation doctor, they told her not to get a second dose. And they said, compared to Veronica, the government said, compared to Veronica, Sharon's evidence is more fulsome. There is a medical exemption form from her neurologist. There is a application for a vaccine injury support form from her neurologist. But they raised the question of why they didn't send in the government application for an exemption if they were willing to send in the other form. I mean, part of this is what we have raised, this issue that she had an off-list condition and that there was a chill on physicians, that physicians were afraid to send in these exemption requests. And then the government also said that Sharon didn't necessarily have a causal relationship between the vaccine and the injury. They said that the application for the vaccine injury support program through the government, that's not a causal statement. It just says that disease is associated with vaccination. That's not proof that it was caused by vaccination. I mean, her doctor thinks it was caused by it. Her neurologist and her physiatrist both say that the literature support that this is a causal relationship. So the government then turned to the issue of prematurity, and prematurity is why we got booted out at the lower court, why we lost at the lower court. The government says that our petitioners needed to use this public health process to get an exemption. And if they didn't use that process, they can't come to court. They needed to try that process first. What we say is that that process wasn't actually even available, that Erica could only get activity by activity exemptions, and Sharon and Veronica weren't eligible to even apply. So it was an illusory process. So the government says that the forms that were available at the time were an adequate alternative remedy that needed to have been exhausted. And the court interjected here and said, well, you have not referred to Erica and you haven't addressed Erica's issue, the blanket exemption. You've only been dealing with Sharon and Veronica and whether or not their off-list conditions would have been considered, whether or not they could have applied. You haven't addressed this issue of how Erica had a listed condition, but the government order in force at the time made her apply every single time she wanted to do an activity or event. And the government responded saying, well, there was still an option for Erica to fill out the form and say that her activities, things she wanted to do, were recurring. They said, I don't know if she would have actually even had to fill out 5 or 6 forms. Maybe she could have filled out, as few as 3 forms and say, I want to go to friends' houses. And the court said, but would she have to fill out a form for each friend? And the government says, well, we don't know because she never filled it out. And the government should have an answer to that since it was their form, but they didn't have an answer to that today. And the court said, well, each friend's house might have been assessed differently and separately. Each activity, like her craft fair that she wanted to go to or her Red Cross training, they might have been assessed differently because everything had a different risks. And they said, well, this activity by activity exemption was only really enforced for a very short period of time. So really only bothered her for a little bit of time. And the court said, I appreciate that this form, this application process, it was all created on the fly. But there's nothing here to describe to describe a type of activity. It is an activity that's recurring, not a type of activity. And the government said, I don't understand the distinction here. And the court said, well, visiting friends is a type of activity, but visiting John Smith is a type of activity. And I don't see anything on the box, on the form, that would have said which direction, which way the government would have interpreted that. And the government says, well, we don't know. She never tried. It could have been filled out just to say visiting friends, any type of activity. I don't think that this is a full answer to this issue. And frankly, I think Erica's activity by activity exemption seems to be something that the court is asking a lot of questions about this. I think that this is something that they are troubled by. The government then turned the question again about this letter from the College of Physicians to doctors. This is what we have called the soft warning to doctors, telling doctors not to give letters of support for exemptions beyond that approved list from public health. But the government says public health never mandated that the college adopt this policy. These were just guidance letters. They only gave guidance letters. But the court said, the college has said that PHO has said exemptions may only be granted on approved grounds. That is the letter that they sent out. And the government responded to say that the college is self-regulating. They're not directed by public health, and communications from the college are not communications from public health, and they weren't dictated by public health. But the court rightly pointed out then, Canadian Constitution Foundation isn't claiming that. The government then responded to say, again, public health didn't mandate any guidance to the college that there were only acceptable conditions to write exemptions letters for. So we were not telling the college, we were not telling the regulator to warn doctors or threaten doctors. And the court then made a very astute observation or question. The court said it would have been very strange or odd that during this time, public health didn't get some kind of notice about this from the college. Surely someone at public health would have been aware that the College of Physicians, who regulates doctors, who are the ones who have to write these exemption letters, that they would have been aware that the college had sent out this letter, and that public health would have a tactical and important reason to respond. The court said one would have thought that if this is a letter the college had sent out saying public health only accepts these conditions, that public health, if they accepted more than those conditions, would have issued a clarification. The court said, I don't know how far it goes in this case because it might be hearsay evidence, but why would public health allow this misinformation, what the court called misinformation, to come from the College of Physicians, the regulators, and prevent physicians from filling out forms for people who needed exemptions? I don't think any physician, the court said, is going to write a document or fill out a document that they know won't be accepted. And this wasn't just a statement from anybody. This wasn't like a blow on the street telling doctors don't write these exemptions. The court said this was a statement from the college, the regulator of doctors, saying that doctors shouldn't write these letters, that anything other than these listed conditions would be rejected by the government. And this is where we interjected, our lawyer interjected to say there was actually a threat that the college, the regulator, would find professional misconduct from doctors that didn't go along with this. And the court said, I don't know if it's deliberate, but what the Canadian Constitution Foundation has done in this case has provided 3 people with 3 different stories, providing a range of scenarios of how these orders could impact them in different ways. And that this range of scenarios has been very helpful to the court in showing the different ways that the orders could be applied to people. Now, I don't know how to respond to that. It is a deliberate choice by us to find applicants who tell a very good story and who are, we empathize with these people, but these are, it's like not really a strategic choice. These are the people that I really wanted to help. And I hope that we are able to help them. So, it's deliberate that we chose people who were really badly impacted and we had urgent concerns for, but it wasn't some type of, really strategic choice. It was that these are people who actually were really hurt and we really wanted to help. So, but it's a nice observation by the court that they found that this was helpful for them to see the different ways that the orders worked. But from my perspective, these are human beings. These aren't like fact patterns. These are people who I've met, who I've spent time with, who I've talked on the phone to, and who I really do genuinely want to help. So, the Court of Appeals is sometimes detached from these things. So they're not seeing the story as the facts are directly unfolding. This all happened 17 months ago. But from my perspective, it wasn't a strategic choice as much as it was a empathetic and actual concern. So the government then talked again about Veronica, who is the patient who has medical conditions that prevent her from being vaccinated at all because she is very medically complex. and has all these disabilities and wanted to use the pool. And the government said, I don't know if a physician would have looked at Veronica and said she would qualify for an exemption or not. But they said it's their position that the court didn't need to even proceed on a charter analysis of what happened to Veronica. And they said that even if it did, because she didn't exhaust the process, she didn't even go and speak to her doctor. We say, there's no point in speaking to her doctor when her condition is off list. And the College of Physicians has told doctors, don't even consider people like Veronica. I mean, it's a bit two-faced in my opinion. The government then said, even if they do decide to hear Veronica's charter claim, there hasn't even been a breach of the charter of her right to security of person or her right to equality in this case. This is when we were about to take the lunch break. Before we took the lunch break, the court said, as you can probably see from our questions, we're concerned about the definition of liberty in Section 7, and we're concerned about the issues around equality rights and Erica, and whether or not Erica, the girl with pericarditis, could have got a blanket exemption or if she needed to apply for an activity by activity exemption. So then we had the lunch break. As I said, I had to watch all of this online due to a security threat at court today. And we had police posted in the courtroom due to a threat. So I ordered takeout to my hotel room and ate bulgogi in bed, which was a nice treat, but I obviously would have preferred to be in court. I was really disappointed about the security issue, but I would much prefer to actually be safe than, risk anything to have attended, even though it really means a lot to me. And I would have liked to have lunch with our lawyer and talk about how today went and what he was planning, but it was not meant to be. And I would rather be safe than sorry. And eating bulgogi in bed is not the worst thing in the world. So after our lunch, we came back at around 2. And most of after the lunch break was dealing with Kip Warner's submissions, but there was a little bit of time that the government spent dealing with the remainder of our case. So the government, as I said, the court was really concerned about this issue of blanket exemptions. They jumped ahead. They said they wanted to address the issue of blanket exemptions in the charter. And the government said the point that they wanted to make on Erica and whether or not she would need to apply many times to get an exemption every time she wanted to do anything. They said maybe 5 or 6 different times. The government, this made me mad. They said that is a difference based on how she was treated. She was treated differently under the scheme, not because of a protected ground like disability, but the government said she was treated differently because of her vaccine status. First of all, I don't think you should treat people differently based on vaccine status. But the thing is, in Erica's case, her vaccine status was actually because of her disability. And the court called the government out on this. They said, how can you make that argument? Her vaccination is a result of a physical disability. And the government said, this goes back to an earlier example about something in the nature of an adverse reaction to the vaccine isn't necessarily a disability. She has pericarditis, but it's not evident that is a disabling position or that she's disabled overall. Now, I can tell you, Erica's experience having pericarditis was frightening. It was terrible. She had stabbing pains in her chest. She had to go to the hospital multiple times, have all of these different physicians treat her and consider her. And her government is saying that wasn't a disabling condition. I don't even know how they can make an argument like that. And then the government went on to say that all unvaccinated people are treated the same way, even if they don't have a disability, even if they have something like an allergy to the vaccine. And the court said, you can't say that either. Like an anaphylaxis may be a disability in this context. And the court said, I can see how maybe choices are not covered by Section 15. It has to be an analogous protected ground. But Erica's inability to get vaccinated is a result of a physical characteristic. And the government said, I think I agree with that. And the court, she then called up a case called Harji, which is from Ontario, that considered vaccine passports as well. That was a different case, though. That didn't relate to disabilities directly related to the vaccine or adverse reactions. It related to unrelated disabilities and religious choice. And the court said that. Does that case deal with disability or with a physical inability to get vaccinated? And the government said, no, it deals with other disabilities and religion. But they said with event by event exemptions, there's some risk that the more close contact you have, the more events you attend, the more risky it gets. So creating this exemption for people like Erica, where they have to apply every time they want to do something, that's to ensure that we protect against serious jeopardy to health. And the court said, I might understand that. We might understand that if there are different considerations based on different types of events. But the Canadian Constitution Foundation in this case has argued that the evidence already establishes that public health was in fact only granting blanket exemptions throughout. So they can't now turn around and make an argument that they needed, activity by activity exemptions and that blanket exemptions were unreasonable or impractical, because that was actually all they were even doing. Even though their form said you can't apply for them. And the court then went on to say that the CCF says on disability, if you could grant a blanket exemption, the fact that you're requiring people with a disability that prevents vaccination means that those people need a separate authorization for everything. This differentiates them from the general vaccinated population who can do everything. This was the court saying this, and this is where our lawyer interjected, and the court said, I'm not mischaracterizing your position, am I? And our lawyer said, no, that is bang on. That is absolutely what we are arguing. So the government, though, refused apparently to concede that an adverse reaction is a disability. The government said pericarditis is a serious adverse reaction to a vaccine, but not of disability itself. I mean, this is a condition that makes you feel like you're being stabbed in the heart. So I think it would qualify as a disability, and it actually prevents her from getting a further dose. So it's a completely untenable position that the government was taking today. So the court then brought up an example from a case called Eldridge. And in the case of Eldridge, this dealt with whether or not hearing impaired people are disadvantaged in the medical system if they're not given interpreters. And the government in Eldridge said, many people can't speak English. And the disadvantage for those people is that they can't speak English. It's not because they're disabled. And the court said this is not the right analogy. There may be disadvantage to not being able to speak English, but here, in this case, in Eldridge, it's because they are hearing impaired. It's not just that they didn't learn how to speak English, it's because they have a disability. And the Supreme Court agreed with that interpretation. There's a distinction based on vaccine status in this case, but that distinction is because of a medical condition. And the government is trying to say a medical condition isn't a disability. And the government said, yeah, not every medical condition is a physical disability. And the court said, but here it disables them from getting vaccinated. And the government said, assuming that analysis, not every difference leads to discrimination. So even if there is a disadvantage here, for Erica, it's not a discrimination. And she says, that's how I would differentiate Eldridge. And having to apply multiple times, every time she wants to go to her craft fair or to her swimming pool, or to her boyfriend's house or her grandma's house or the restaurant or the mall, or to take her Red Cross lessons, having to apply each time she wants to do any of those things, plus all the unexpected, unforeseen things that would have to come up, the government says, no, that doesn't rise to the level of discrimination. Even though there is a differentiation and she's treated differently, it's not discriminatory. And the court said, well, what about that issue of emergent events, things that suddenly come up? The Canadian Constitution Foundation has said it would be impractical to get exemptions for some things, and we gave the example of a funeral. Our point is about emergent situations without sufficient notice. And yesterday we said this to the court. We're like, how many things have you done in the last 10 days that you didn't know were about to happen? Lots of things. We make plans on the spur of the moment. We shouldn't have to go through a government agency every time we want to do that. But essentially, that's what the government was requiring Erica to do. And the court asked, what about these examples of things where, practically speaking, a person like Erica without a vaccine, they wouldn't be able to get an exemption in time? And the government said, well, emerging situations, that was a challenge throughout the pandemic. And many people throughout the pandemic missed out on things that came up on short notice. And the court said, but not at this point in the pandemic. Like, at this point, when these vaccine passports were enforced, like, society was getting back to doing things. And the government said, no, not everyone was vaccinated at that time. There were still a lot of people who couldn't get vaccines. And the government said, and the court said, no, not really. We had vaccines at that point. People could do things on short notice, and we weren't waiting for people to get vaccines at that stage. Everyone who had wanted a vaccine got one. And the government said, well, the population under 12 was still waiting to get vaccines. And then our lawyer interjected and he said, but the orders on vaccine passports didn't apply to people under 12 years old. So what is this argument even about? So the government kind of abandoned that. And they said, I don't have anything else to add on this oral submissions. The court then started trying to suss out exactly when these blanket exemptions versus activity by activity exemptions started. And they said, when did they start giving the blanket exemptions? And the government said January. The form, I believe, changed in January. And the court said until then was the practice to just give blanket exemptions, even though the order didn't permit it. And the government said yes. Now, this actually isn't accurate. And we responded to this in our reply. We said that the orders actually changed February 16th. So the government gave itself an oral argument today. They said that they had changed things like a month before they'd actually changed things. And having your rights violated for a month by the government, I mean, that's not a small matter. The government then turned away from addressing our case to the other party. That's the Kip Warner case that I'm not involved in, so I'm not going to summarize what happened. They did address broadly, though, this issue of Section 7 and the right to roam. And they claimed that, going over to a friend's house for the purposes of socializing doesn't actually engage Section 7. It isn't fundamental enough to our personal identity. And they said even if it does engage Section 7, limiting it is consistent with the principles of fundamental justice. They then turned to the issue of how these public health orders came with a penalty of a possible term of imprisonment. And they said that doesn't engage Section 7. It's a law with a possibility of a term of imprisonment, of course, engages Section 7. But they said it doesn't because these were not absolute liability offenses. There were available defenses in the Public Health Act, but the court didn't seem to buy this. They said, strict liability versus absolute liability offenses, that speaks to principles of fundamental justice, but not the question of whether or not liberty is engaged or not. We then, they responded to a few more things from Kip Warner's submissions. We had a very, very short afternoon break because we didn't want to, the court said that they will not sit past 4:00 today, Pacific time. And so we had a short 10-minute break. Then our lawyer, Jeffrey Trotter, made replies. He replied first on whether or not the possibility of imprisonment engages liberty. He said, of course it does. He responded to the government's inaccurate claim that the order changed to allow blanket exemptions from for medically exempt people, that blanket exemptions began as part of the order in January. They did not. It began in February. They addressed that claim that children had to wait longer for vaccines by reminding the court that the order didn't apply. It didn't apply at all to vaccines, or sorry, to children. And then on the Section 7 issue, or sorry, the Section 15 equality issue, there was some question on whether or not Erica was even disabled that I went over that was like so enraging. And Jeffrey said, you know, it's clear from Erica's affidavit that after her first dose, she was seriously disabled, and that if she got a second dose, she would be seriously disabled again, and it would actually seriously jeopardize her health. And surely that qualifies for Section 15. Surely that is a disability claim under Section 15 of the Charter that guarantees the right to equal protection under the law. And it would be a terrible legal policy to make Erica get that second dose before she could actually claim a disability. Jeffrey responded to the government submissions about Sharon, where public health had said that her brachial neuritis, her adverse reaction, was merely associated with the vaccine, not caused by the vaccine. And, you know, Jeffrey rightly pointed out that is not what her neurologist said. Her neurologist said it was caused by the vaccine. Her physiatrist, her rehab doctor, said there is a link in the literature between brachial neuritis and the vaccine. Her doctors made that link. They never denied that link. Public health got it wrong about what the doctor said. Public health seemed to think there was a lack of causation here, but her doctors never said there was a causation problem. They said that it was connected. There was also our lawyer addressed the concern that the panel seemed to have that the claim for the liberty interest is too broad, that this right to roam, the idea of like roaming freely around society is protected by the liberty interest, that's the panel seemed to be concerned that was too broad. And in this case, Jeffrey said for the Canadian Constitution Foundation that the vaccine passport orders implicate the right to make fundamental personal choice free from state interference. And that's a different type of liberty impacted by the threat of imprisonment. And freedom of movement is also a different type of liberty. There are different types of liberty, and all of these were impacted by the vaccine passport programs. So that concluded our submissions on reply. Then the lawyer for Kip Warner got up and made some submissions, and that was it for the day. We wrapped up court at around 4:00, and the court concluded by saying we reserve our judgment. That's usually what happens in these cases. And, you know, one of the questions I always get on these live streams is when are they going to have the decision? And I don't know. I never know when the decision is actually coming. Typically, we get them within 6 months, but sometimes it can be shorter and sometimes it can be longer. So I hope that you guys enjoyed my coverage from today. Again, I was very disappointed that I wasn't actually able to attend in person today. I came all the way here and I would have loved to be in the courtroom, and it matters a lot to me that I was there, but I'm happy that I got to observe. They gave me a live stream to watch and that I could still summarize it for you even if I wasn't in the courtroom. And of course, I'm texting with my lawyer all day and he's filling me in on what happened. The last thing I'll say before I go is if you guys are interested, I have a new book coming out, Pandemic Panic. You can order it on Amazon, and it deals with this case. It doesn't talk about the appeal because the book is already being printed, but it talks about the case leading up to it. So if you want to hear more about the stories of Erica, Sharon, and Veronica, this book, Pandemic Panic, outlines their stories and what happened to them and what led up to the appeal today. And if we sell enough copies, I'll do a reprint where I fill you in on how the appeal decision goes. So now I'm hoping to go and get some dinner, although I'm still pretty full from my lunch. But I appreciate all of you so much. It's always so nice to see how many of you tune in to watch these live streams. All right, wish me safe travels back to Ontario. Bye.